Okay, hello everyone. Welcome to DAO Talks. I'm DeXe Heaver from DeXe DAO. We have two guests today, so double the fun. Hope you're ready for a nice, fun talk about legal strategies for DAOs, right? DAOs, of course, are decentralized autonomous organizations, but as part of being in any sort of organization, there's always legal strategies to consider, legal issues to consider. So we have two people today joining us. One is a community member who submitted a proposal about legal structures for DeXe DAO, and another is an attorney who's very knowledgeable about law and crypto and DAOs. So I would love to hear from both of them. Let's have them introduce themselves real quickly. Taras is the one who submitted the proposal. Taras, could you tell everyone a little bit about yourself?
Yeah, hello everyone. I'm happy to be here. Hello community. I am Kyiv-based legal professional. I'm working in Web3, crypto and blockchain spheres, but here I'm representing myself as, I suppose, more community member because I think that we are on that point where we need this, legal strategy, and we should implement it as soon as possible.
Thank you, Taras. I'm sure we're going to talk a lot with you. But first, I would love for Irina to introduce herself and tell us a little bit about her as well.
Hello, thank you very much for having me. My name is Irina Heaver. I'm a partner in an international law firm headquartered in London. We look after basically 60 plus jurisdictions, and my practice focuses on emerging technology, blockchain, and crypto, of course. I'm a crypto lawyer based in Dubai and Switzerland. I'm in Switzerland right now. And in Dubai, our law firm is native crypto law firm. We've been advising government regulators and entrepreneurs since 2016. This is how deep we are involved in crypto and all the matters. Currently, we're representing several governments, and one of the coolest initiatives is advising a couple of governments on structuring DAOs, and they would like to copy what Switzerland has done. I'm sure you know that Ethereum Foundation has been set up here in Switzerland in Crypto Valley back in, if the memory doesn't, if memory serves me well, back in 2016 or 15. I'll double check that. So, and since then, FINMA, the Swiss regulator, has done a lot of really cool sort of progressive work in the space, which allowed Swiss Crypto Valley to flourish and attract so many amazing companies and so many amazing people. So there are several regulators out there in the world who would like to replicate to the extent possible, of course, because national laws always take precedence over specific laws, to replicate that in their native jurisdictions and compete with Switzerland, which is great. More competition out there from progressive governments, more progressive work from cool governments make the life of projects like yours and make the life of entrepreneurs much better and much easier. So I'm all for competition amongst governments to make it better for all of us who are working and building in the crypto space.
Totally. It's definitely better to be compliant with laws rather than dealing with them afterwards. And I could tell Irina is extremely knowledgeable. I didn't even know Ethereum Foundation was set up in Switzerland. We're definitely going to dive more into all of the legalities and legal considerations here today as much as we can. But before we get too deep into it, I would love to ask Taras to describe the proposal, kind of give us a top-level overview of what it's all about. Of course, everyone can find it in the DeXe DAO forum and comment on it and participate in the governance. But before we get there, it would be really good to know what's it all about,
Yeah, hello everyone once again. So some background information. When I placed my proposal, I can't even imagine that there will be such amount of attention from community members. And it's good, really speaking, because all of us could see these, last regulatory actions against many famous crypto projects like Luna, like Ripple, and so on and so forth. These projects didn't care about their legal strategy, and I suppose that we, at that point of time where we should care, because from one side we have permanently growing community, permanently growing protocol, and we should implement some, off-chain instruments to cope with some matters and issues with which we can't cope on the on-chain level. For example, just very simple example. If we give someone grant, who will claim money back if grantee will, for example, breach the grant agreement? Just as an example. And there are, many off-chain matters with which we should cope as for now, on this stage of our project development. On the other side, the other, ground for my proposal was this, growing and growing and growing regulatory pressure on the Web3 and blockchain projects throughout the world. You may see all these, for example, SEC actions against Terra, where they use some Twitter post where they, accused some community members and so on and so forth. That's why I understand that we need some legal entity or some, entity which will limit liability of our community members and which will handle with all these off-chain matters on behalf of all the community members. And I suppose, and this is my just personal feeling, that Swiss association will be the best for our purposes, because this instrument will give us flexibility and will give us possibility to connect our own chain governance, which is developing from day to day with our own chain governance, which is developing from day to day with our off-chain, DAO legal wrapper. After this, I have connected my colleague Irina, and she provided me with preliminary consultation with respect to this. And as a result of these sections, my proposal was drafted and published, something like this.
Amazing. And this feeling that you expressed of being surprised at how many people, this resonated with and how much attention it got. I've seen this in several DAOs, being myself a member of several DAOs, how people don't even realize how much power they have, how much importance they have, how much freedom to participate they have, right? You don't need Vitalik, to top down decide something or propose something. You don't need Elon Musk or whoever, Sharon Powell, whatever. Any member can propose something amazing, and then the community can pick it up. So I love seeing it in action. As a DAO member, I really get and appreciate what you're doing. So thanks for that. Just as a member of the DeXe DAO myself, I wonder, and this may be a question more for Irina, but we're talking about, of course, having a legal basis for the DAOs to, on top of the DAO internal code, to have a sort of legal wrapper. But from the legal perspective, I guess, Irina, can you talk a bit about why it's needed? What are the different things to consider as an attorney, as someone who knows various legal ramifications to deal with?
Sure. So first of all, I would like to applaud Taras for being a proactive member of the DAO, and this is what DAO is all about. Each member brings his and her own strengths, and when you see something, it's like when you see something is not up with the DAO, just say it, right? Put in a proposal, and that's how That's the beauty of being a part of a DAO rather than working for a company where there is a strong structure and you sort of can only talk to your boss and the boss talks to the boss, etc., etc. And by the time you talk to the main boss, I mean, you could just as well forget about doing anything. So first of all, I'd like to applaud you for taking a proactive stance in looking after yourself and your DAO. I mean, that's how it should be. But before we start talking about the legal ramifications of DAO, what is a DAO and what is not a DAO, let's talk a little bit about history, if I may, please. Just a 2-minute little history lesson.
Absolutely, of course.
Yeah. So if we so the current structures, the current legal structures of a limited liability company, LLCs, and we have LLCs all over jurisdictions. Sometimes they're called slightly different, but the idea is limited liability company, right? LLC. This notion of LLCs is only 45 years old. Literally, in 1977, Wyoming, it's a state in the US, first introduced an LLC structure. And now when you deal with the regulators, you deal with the real world, if you don't have an LLC or any other sort of socially acceptable or legally acceptable structure, then they freak out, right? You cannot open a bank account unless you're properly structured legal entity. You cannot enter into contracts. You cannot hire people. You cannot fire people. You cannot bring actions against evil people who are trying to, for example, I don't know, tank your DAO, etc., etc. But the LLC structure is only 45 years old. And we all act, or sorry, not us, but the governments act like it's the only thing ever available. And when we come up with DAOs and want to sort of bring in the on-chain DAOs into the real world, they freak out, which is actually a little bit confusing. Probably they need more history lessons than us. Because if we think back centuries and centuries, how do people put together their resources, their time, their strengths? They did it through guilds. They did it through associations. So the origins of DAOs can be traced back to the Middle Ages, when merchants and craftsmen, they joined forces together to create guilds. For example, you manufacture a really beautiful plate and I manufacture a really beautiful cup. So we form a guild and pull our resources together, protect our interests, look after our warehouse, because in the Middle Ages there were people who wanted to come and take things away from us, just like today. Basically nothing is different. So we would protect our interests, but also maintain high standards of our trade. I make beautiful plates and I'm so proud of my trade. So I don't want, somebody making really shitty ones and really sort of like dumping inferior product on the market. And those are medieval beginnings of companies and guilds. And what do we see now? We see now exactly the same. What a DAO? A whole bunch of developers, whole bunch of marketeers, whole bunch of people with different skill coming together, building an enterprise together, or building some sort of economic efforts together, and that's basically the history, right? Then in 17th and 18th century, we had an emergence of joint stock companies. So big shipping companies emerged, like Dutch East India Company from 1602, and also the British East India Company in 1600s. So these companies gave the rise of shares. So you could buy a share in that shipping enterprise. So that was a huge development as well. And then, like I mentioned, in 45 years ago, LLCs came together. So if we talk about DAOs, I would argue that DAOs is not a new form of company. It's actually, we are almost going back to the roots of the humanity, how people always interacted. You bring something of the value to the table, a person next to me brings something to the value of the table, and we build this autonomous organization, or associations as we build them in Switzerland, or guilds. Guilds are very popular right now. Let's say gaming guilds and Gamify, etc., etc. So when we talk to regulators, I start with this history lesson, and then their eyes open and go, oh, okay, fantastic. So you're basically just trying to replicate what humans have been doing for centuries and centuries. So we should not be shocked by that. That is right. But however, we still have laws and regulations in each jurisdiction. blockchain doesn't have borders, but countries have borders, and each country has its own rules and regulations that we are all subject to, whether we like it or not. So, and that is why there's so many legal challenges for DAOs, for on-chain DAOs. And those challenges are plenty. Taras mentioned some of them, like protecting the interests of the DAO members. There were several cases in the US mainly that the DAO members were held personally liable for the actions of the DAO. And this is what you don't want. If you're a member of a DAO, you want to contribute to the DAO, but you also want to make sure that the regulator will not come up to you and will not take your and your personal assets are not risked. Sorry, Taras, you wanted to mention something?
No, please proceed.
Okay, great. So yeah, so let's talk. So that was a little 5-minute history lesson, right? And I always like to joke that the humanity did a whole circle around, right? We came back where we started centuries ago, and this is, in my opinion, is how our kids will engage in work. They will not go to the office. They will not work for someone. They will be part of multiple DAOs, because why not? You can contribute to multiple efforts, multiple enterprises. But back to the legal challenges, of course, the regulatory compliance is a huge one. For example, just today, SEC brought action against Binance and CZ for regulatory failures. I have not looked into that in details, but this is what you don't want to be. You don't want to be sued by SEC. I litigated against SEC when I was in the oil and gas sector. They sued my client, and we fought against SEC and DOJ for 7 years. And this is what you don't want, because fighting SEC and DOJ, that's, huge resources are required, and you don't want that. So, like I mentioned, DAOs operate across borders. However, within each border of each jurisdiction, there is own regulatory sort of laws and regulations you have to comply with. That's why if you have a legal wrapper established in one jurisdiction, you need to comply with the laws of that particular jurisdiction. That's why legal wrappers need to be set up in a friendly country, and Switzerland is one of the friendly countries at the moment, and has been since quite early 2016-17. Another thing is the legal entity status. For example, like Taras mentioned, if somebody breached a grant contract, how will you go after this entity or person or group of people? You can't. Or actually, even from the beginning, how do you enter into contract to give that grant to start with? How do you enforce that contract? How do you then try to make sure that the other party is performing, which is quite important. And you can't do it in your personal name, and every member of the DAO cannot sign it personally. That would be, a nightmare to manage. Another area is the sort of compliance with various KYC, AML, and all the other procedures that come up. Because whether we like it or not, we need to operate. I understand we're on-chain, and it's, but we still need to operate within the remit of the laws. Intellectual property rights. You might invent the most amazing protocol capabilities tomorrow, so you'll have to protect that to the point, to the extent possible. For example, of course, I understand in blockchain we have open source protocols mainly, which is great. That's why I love our industry. But however, there are a lot of DAOs that might want to protect their proprietary inventions. So if you look on the balance of probabilities, creating a legal wrapper that works protects the interests of every member of a DAO, but also allows the DAO to interact with the real world, pay taxes, even if a little bit, we might still have to pay taxes somewhere, and claim home, right? You claim as a home Switzerland is, for example, Switzerland is my home, is my jurisdiction. I'm here, I'm compliant with the current laws, and no government can, well, that's not true. Other governments, it will be harder for them to go after you if you already have a home. Because if you don't have a home, then it's anybody can come after you and claim that they have jurisdiction over you. So if we look at it, proper legal structuring has only benefits. Yes, we need to spend some time structuring, but I don't see negatives in that.
That's super fascinating. I'm thinking you were talking about guilds, and it's funny how it's coming back to guilds. I can think of, Raid Guild DAO, for example. That's definitely along those lines. And totally makes sense. I wonder, with smart contracts obviously being the code that acts as law, that acts as a sort of enforcement, but of course in the real world, like you mentioned, it needs to be reinforced somehow. So I'm guessing, do they work well together? Have you found the smart contract on the coding side and specific jurisdiction of, let's say, Switzerland in this case, where the law looks at the code, looks at the smart contracts, and then of course at the whatever jurisdiction the DAO is registered in, and that kind of forms the basis of the adjudication of disputes, etc.
So we're mixing a couple of things together. We need to separate them. The on-chain DAO and the smart contract and the voting and the things that are happening in the on-chain world, they work together with a real world legal entity, but they don't necessarily completely, gobble up each other or intertwine. They work together in parallel. So, and that's why I like association, which Taras mentioned. It's a very flexible legal entity. In the charter of the association has the right to write up how they want to govern, which smart contract governs, the also changes to the smart contracts. Like, for example, you might want to introduce additional governance within your DAO. So it's a very flexible, so it's not restrictive, but at the same time provides with a limited liability to the members, provides with certainty with regards to interactions with the real world, but it's not restricting you. It's not telling you, well, if you chose this way, that's how you have to do it for the rest of the world. And the associations is the logical development of those guilds, of those trading associations, right? People got together, people are working together, things can change, things can approve. And the good thing about associations, the members can vote. Hey, we don't like how things are done now. We want to make changes to our charter of our association. We want to implement new provisions. So it's basically yours, right? They're not two different things. The legal wrapper belongs to the DAO, and the DAO makes the decisions governing which way it goes, left, right, center, and how many jumps they have to do before certain happens. That's the beautiful part of it. There are other type of legal wrappers available, but they're not flexible at all. However, not only they're not flexible, but I think Taras has mentioned the regulators are penetrating those wrappers and bringing action against DAOs. That's what you don't want either. You want to be flexible, but you also want to be protected.
That totally makes sense, and it does sound like the association is a form that's very compatible with the DAO, very similar to the DAO. Though you mentioned specifically Switzerland, right, in the proposal Taras did too. What makes Switzerland the best? Switzerland associations the best? Is it just the history of Switzerland, the liberal policy of Switzerland? Is there something specific? I know nothing about Switzerland other than the most basic stereotypes. So I'd love to hear your expert opinion on it.
And my personal opinion here is, there are many points which makes Switzerland very attractive for blockchain business, for Web3 projects. For example, if you look at the list of the biggest, Web3 projects as well now, I suppose the majority from them, including Ethereum, including Polkadot, including Near, have established their legal wrappers in Swiss. This is first of all, and this is, I suppose, the biggest plus of Switzerland, best practices, very strong best practices. The second one is Switzerland is very, and I suppose the most reputable jurisdiction from the other where we could establish legal wrapper. For example, I have considered Cayman Islands. I have considered Panama, and this is not what we want in DeXe, I suppose, these offshore gray jurisdictions, and I don't think that we want to connect our project to offshore jurisdictions. And the third, my point here, as Irina mentioned, I suppose that as for now, regulatory authorities of Switzerland give us, protection from, from the regulatory authorities of the other countries, and on the other hand, the form of Swiss association gives us, I suppose, the maximum extent of flexibility, and taking into account our, I suppose, complicated on-chain governance model. I think that no jurisdiction could be used in our case except for Switzerland, because in Switzerland we could, I suppose, reflect almost all, features of our on-chain governance in constitutional documents of legal entity. Something like this.
And Irina, as the legal expert who I'm sure knows Switzerland well, what do you think? Do you agree that it's really good jurisdiction and makes sense?
Well, it's easy for me to talk very positive about Switzerland. I have I spend half of my time in Switzerland, the other half we're talking Dubai. So of course I will only mention awesome, fantastic things, but I'm also objectively that's the situation with the with the horrid stories we see coming out of other jurisdictions where the regulators basically don't tell you what to do, don't tell you how to do, but after you've done it, they come and sue you. That's called regulation by enforcement. This is what you don't want. This is horrible. You don't want that as a lawyer. You don't want that as a founder. Imagine you're building something and you try to talk to the regulator and they're like, yeah, just continue, but you're halfway there, and then they come and sue you for the way you've built. That's what you don't want, and that's what Switzerland doesn't do. FINMA, the regulator, is a very proactive regulator. You can ask them specific questions. You can send them a specific request. They will answer. Yes, they take a while, but everything takes a while in Switzerland. We are in no hurry. We're very relaxed sort of atmosphere. But you can engage with the regulator. You get no action letters. You get confirmations that it is all is hunky-dory, please continue. And also, once you've claimed, and that's one thing. Another thing, as Taras mentioned, it's great to be in great company, because you are the summary of 5 people you spend your time with, right? So why would you want to set up in some strange places where you can set up in Swiss Crypto Valley, literally next door to Ethereum, literally next door to Tezos, Cardano, Casper, and other sort of large protocols. Near, I think, yes, Near is in Switzerland as well. So you want to be in company where, in great company where innovation is taking place. You want to be rubbing shoulders with, big boys, so you can aspire to develop. I know DeXe has really big plans, so that's what you want, or that's where you want to be, right? And another thing is it gives you this regulatory certainty. You've established a home for yourself. This is my home. You comply with the rules and regulations of your home. So other hostile regulators or hostile players in the industry would not want to come after you, because then they have plenty of others to come after who either don't have a home or have a home in a questionable place. It's easier to go after those people than go after people who have done everything to protect themselves. You go basically after low-hanging fruits, the ones are easy to pick, right? Why go after project that has done everything possible to protect itself? Like, that's just not very that will not be smart of them. And that's my view. And of course, Switzerland has its own negatives. Things takes a little bit longer. In Dubai, for example, it takes 5 days to establish a company. In Switzerland, it might take 2 weeks. But another thing is, we've got great banking here. There are a lot of crypto native banks, so opening a bank account in the UAE for a crypto company is almost impossible, whereas in Switzerland it's not only possible, but we're doing it every day. And a lot of and also being set up in tier 1 jurisdiction, not in some great jurisdiction, gives great possibility for you to enter into various partnerships and contracts with other reputable parties who are building in this reputable space. Look, I'm not saying if you're not set up correctly, or if you're set up in a jurisdiction which is a little bit off the beaten track, I'm not saying you're not reputable. I'm not saying that at all. What I'm saying is, if you've done everything possible to be as reputable as possible, that's the people you attract, and that's the partners you attract, and it's the people and partners you want to attract and be associated with, in my opinion.
That totally makes sense. It's that you do attract better people and less attacks if you really put in the work and establish yourself in a good jurisdiction. And Switzerland really sounds amazing from everything you just said about how it creates a total environment for crypto companies to thrive, for people in crypto to do everything from banking to networking to obviously building DAOs. Speaking of building DAOs, Taras, let's get into the proposal a bit more. Of course, there's going to be proposed a specific governance model, and it would be really good. I think I'm sure there's a lot of DeXe DAO members listening in now and going to listen on the recording as well, for them to understand it more as they go and read the proposal. Can you talk a bit about that future governance model, how it's going to work, assuming that the proposal gets approved as is? And of course, for all the members listening, the whole point of putting a proposal up is that you can go, you can comment, you can suggest things to make the proposal even better. This is definitely a community effort.
Yeah, thank you. Sure. So as for now, proposal containing very few words, I suppose, with respect to future governance model. But my understanding about future governance model, and I suppose that Irina will agree with me, that this Swiss association should be solely ministerial structure. I mean that this Swiss association should act only and strictly in accordance with decisions of the DAO. And this one of the points to consider when I have chosen this Switzerland, because Swiss legal model and Swiss regulations gives us possibility to establish such model in constitutional documents of Swiss association. So I suppose that governance law will look like as, for example, DAO make decision, and only in the frames of these decisions, for example, council members could make some agreements. For example, DAO makes decision to allocate 100,000 of DeXe tokens for grants. Okay, no problem. In such a case, council member should make the agreements with prescribed by the decision of the DAO legal entity to which DAO wants to give this grant, and that's all. That's all from my side. So council members should not have their own discretion. This is, it's my opinion, and I suppose that we will try to reflect these in constitutional documents, and we should try to reflect in constitutional documents that in case the council member breaches, for example, his or her responsibilities, or does not act to the best interest of the DAO, DAO should have the right to change this council member. Therefore, from my point of view, to sum up, council members should have only, something like operating functions, and should act strictly in accordance with the decisions of the DAO, and that's all. No, freedom to act, no freedom to make some transactions without DAO voting, and so on and so forth. This is my opinion, personal, as community member.
I see Irina putting up an emoji. Irina, anything you would like to add in terms of this law?
Yeah, I'm giving 100% agreeance here, because that's what the legal wrapper is for, right? The DAO is the head, and the legal wrapper is just executing the decisions of the head and not more. The association model allows for that to happen, and allows for the DAO members to oversee the execution, right? Like the head will oversee the hands, which is also valuable, because you don't want the council members to go rogue on you and start doing other things, which has happened actually. The prior legal structure used for protocols was a foundation, and unfortunately it did happen, and there are various cases between the founders of the foundation and those people who are running the foundation. They're actually like legal cases. I think Tezos is one of them. You can Google it; it's publicly available information. And that's why we retired the use of the foundation structure here in Switzerland, and we're using the association structure, which is more flexible, gives the DAO more ownership over the legal wrapper, and also the people who are the council members executing the decisions and the will of the DAO, if I may describe it in such a manner. And so yeah, that was the 100% emoji there, a full agreement.
I think that's as good as endorsements can possibly go with 100%. That's amazing. Just a real quick pause to remind everyone listening, or in our chat, that we're definitely open for questions. This is an AMA format, so anybody just pop in the question, raise a hand, and I'll be sure to call on you so that Irina or Taras, depending who your question is for, can answer them. We still have some time for that, and I think that makes the discussion even more dynamic, and of course more true to the DAO form. So just raise a hand if you want to ask a question. In the meantime, as I was listening to both Taras and Irina, I was thinking how DAOs are, and governance in general, revolves so much about treasury management, about the funds, right? Show me the money kind of thing, where money really votes, and so much is done with the treasury, and of course also with the council members. How the council members compensated? How Taras, do you propose that it's structured in a way that doesn't get them, I guess, corrupted, and make sure their incentives are aligned? And just in general, how in your proposal is the treasury spent by both the DAO and the association? What mechanics are you seeing? Not to get too deep into it, but just some kind of general top level.
Yeah, thank you for your question. I suppose that taking into account the nature of the Swiss association. Swiss association is non-for-profit structure. I suppose that compensation should be minimal, because community member who works in council, who works as council member should understand that he or she works on whole and very, very big and interesting community, and I suppose that this is the biggest compensation. But once again, I suppose that the best choice here will be to review the market and make the minimum compensation for such kinds of organizations. I suppose that we will have additional information in that regard in the future, and I will share with community this in new proposal, for example, or on the forum.
And then can you talk about some samples of how the treasury would be used in your vision, right? Just practical examples. Let's say I have 100K in the treasury that I want to distribute for some governance initiative as a DAO member, right? And I want to make a proposal, and I know that there's an actual association and these council members. How would I start? What would I consider? What are some additional things to consider with the off-chain association part of it? Just kind of walk me through as if I'm a DAO member who knows very little, who wants to make sure it doesn't get confused, who knows that now there's a legal part to it as well, as the DAO part, and wants to, let's say, spend 100K on a marketing initiative, let's say.
Yeah. Okay. Thank you. So, once again, from my understanding and from my point of view, council members should have no connection to treasury management and to transfer. The role of council member is to make the relevant agreement when there is the decision of the DAO to allocate some amount of assets is in place. Therefore, the first step is, for example, I am as a community member or someone else from our community propose some, for example, some allocation for, once again, marketing or for some conference. We are voting for this proposal, for or against, and if this proposal is agreed between the community, in this point, the council member could make the relevant agreement. And I suppose, once again, that the relevant transfer should be made by the DAO directly by means of multisig as a result of DAO voting. Therefore, there is no connection between treasury, direct connection between treasury management and DAO council. The role of legal wrapper council member is to make the relevant agreement and to make the relevant relations legally binding. But our role as a community to vote for some allocation or transfer of assets and to initiate this transfer by means of agreement on the relevant proposal, something like this. This is from my point of view.
Totally makes sense. Just to shift gears a little bit, I just had a question in my mind about for Irina, because in the news there's all these things about DAOs being accused of, or crypto being accused of in general, but people don't know better, being just money laundering or a bunch of other things that are not true for the majority of the blockchain industry. Can you talk a bit about how the legal framework of especially a reputable country like Switzerland does not, give cover for illegal activities, but maybe on the other, quite the opposite, gives legitimacy to legitimate projects that are pursuing legal, legitimate tasks or organizational tasks, and how it's legal for legal things and legal pursuits, and not rewarding bad actors by giving them cover or anything like that, right?
So there's several things here to unpack your question. It has been proven over and over again that cash, fiat, US dollars is used for money laundering, and only less than 1% of crypto is used for money laundering. But of course, the hater's gonna hate, nothing you can do about it. So that is being used against crypto, that, crypto is used is used by criminals and it's for money laundering. And we're in the year 2023. When I went into crypto full time in 2016, and I was the general counsel of a very reputable corporation called Maersk, the largest shipping group in the world, so that people said, what are you doing? You're going into this Bitcoin space, only the drug money is there, and horrible, horrible things people were saying, and people are still saying that. I mean, so people are saying this to me for what, almost 8 years now, and you know what? Hate is gonna hate. But it has been proven over and over again that it's not the case. Now, in the situations where it is the case, let's look at that 1%, right? Yes, some dodgy, for the lack of a better term, centralized exchanges are set up on some coconut islands with little or no oversight, right? Like FTX, perfect example. But FTX was, a full-on illegitimate enterprise from day one, right? So in your case, you're not planning to be handling user funds, you're not interacting with fiat on ramps, you're not doing the payments. So in your case, being accused of money laundering or some other illegitimate activities, you really have to try really, really hard in order to be accused of that, because I don't even see how you can master that physically. And then being set up in a reputable tier 1 jurisdiction with various, checks and balances in place. I mean, as association, the council members of associations will have to file the reports, will have to file with the authorities, and the filing obligations are not very extensive, but there's still some checks and balances in place. And so there's even less a chance of being accused of various illegitimate activities. If you put all this on, sort of like if you wrap it all together, being in tier 1 jurisdiction, of course it helps. Of course it gives you that credibility, as we discussed before, and you're also rubbing shoulders with other credible projects, and opening a bank account with a very reputable crypto bank that gives additional securities there for everyone, that no, you're not engaging in any money laundering, because your bank will literally not allow for that to happen. So if you put all these things, stack those things on top of each other, you have this really nice a stack which protects you, so nobody can accuse you of such activities, even if they wanted to. But again, hate is gonna hate. There's always somebody out there who wants to come up with all sorts of ridiculous arguments, but you'll have the law on your side, and you'll have the facts on your side. So it would be very hard to discredit you if you have both the facts and the law on your side.
And it's definitely good to have the law on your side, and it's clear, from everything you're saying, that it's not just a rubber stamp or anything like that, that it's legitimate. Yeah, like you said, tier 1, legitimate legal structure that requires work and requires proof of being compliant. And that's definitely encouraging, because just thinking as a DAO member myself, right, going into a DAO, I don't know if it's fraudulent. I don't know what's happening, right, until I do, and seeing that the team or the members have gone through the trouble of getting legitimate.
That's actually a very good point, right? Why would I decide to join this DAO if it's completely unstructured, It's completely haven't thought about protecting me as a member. So that's a very good point. Why would I be joining that DAO? But if that DAO did everything possible to protect me as a future member, structure properly, that it shows to me that this DAO has the ducks in the row, and me contributing my time, my talent, my money, because I'll have to buy governance tokens, right? It shows to it proves to show that this is the DAO I want to be involved with. That's a slightly different point from money laundering, but it's a very, I think, very important point. Another important point is the following: your protocol is there to allow other DAOs to build on-chain DAOs. So you should be the one leading the charge and leading in being properly legally set up, because then you can give them examples of how to do that properly, right? So you are here to service other DAOs or help other DAOs with on-chain governance and on-chain setup. And then imagine if you don't have your ducks in the row, that will not look very credible. Why would I be trusting my own chain governance to the guys who haven't thought about protecting themselves first? So I think either way you look at it, getting your ducks in the row has only the positives and no negatives. And of course, being a lawyer, I always think of the worst case scenario. I think of the regulatory action by a very hostile regulator. I think of being funded and accused of all sorts of really horrible things in life. So I think of the worst case scenario, and then we'll try to protect the client from those worst case scenarios. And if we're lucky, not even 50% of them take place, but we have to structure for the worst situation, because then if it doesn't happen, that's great, you're protected. But if it does happen, well, that's great, you're protected as well.
That's brilliant. That's actually why it's so good to have you here, as an actual attorney to understand this and thinks of the worst case scenario. Because as a DAO member, I'm a true believer. I'm thinking it's always going to go great. Everything's going to be wonderful. There's going to be no issues. And just like, there are audits for the code, there's all these technical security experts trying to probe every possible leak and worst case scenario of any tiny thing that could go wrong. It's good to have lawyers and just DAO members, for that matter, who are thinking about these worst case scenarios and designing systems that prevent that. And it's definitely good to prepare for worst case in order to not have it. So I appreciate that as a DAO member. I see we have a request to ask a question from Roman. Let's hear Roman out. Okay, let's see. You should join now. Okay, Roman, if you can speak, please ask your question.
Yeah, hi guys. Well, first of all, I want to say thanks to both of you. Of course, it was really interesting. But I want to speak more about the council. Actually, I want to ask, can these members protect against hacks in DAOs? Can they protect the DAO from cyber attacks, or it's just about enough chain execution? And how big is their influence and power?
Who was this question for? I think Taras would be best positioned, because he knows the DAO from the inside out.
Yeah. Okay. Hello, Roman. Roman, hello. Thank you for your question. I suppose that we should switch off-chain mechanism only in case we need, off-chain performance of some decisions. I suppose that hacking, this more about technical side, and once again, there is, no points to switch council members and DAO legal wrapper in this case. But if we talking about, for example, protecting members of the DAO, yes. For example, in California, I have reviewed yesterday the decision of the court of California, where there were some, claims from DAO members to the other DAO members about hacking, and stealing assets. And in such a case, plain community members are protected, but because such claims will be directed to DAO legal wrapper, but not the community member. Once again, not to council members, but DAO legal wrapper as distinct legal entity. Something like this.
Irina, would you like to add anything to that? Not that you have to, but if you would.
No, I concur. Mixing these two things up is not very, they kind of like don't come from each other. So the real world execution is one, and the protection of the protocol is another. But then, if you protect the protocol, you found the culprits, you found the hostile party that tried to attack you in some way or another, that's when the real world legal wrapper comes in to sort of bring action against those hostile parties. That's so it works together in hand by hand.
Awesome. I'm seeing that we're reaching an hour, so to respect both of your times, I want to start to wrap this up a bit. I have a question. Well, I get a similar question, but I'll ask it separately. So for Taras, let me ask you first. For everyone who maybe just tuned in or who's listening to the recording and will hear just this part, can you kind of give a TLDR, just a really, really short summary version of the proposal and why it's important for the DeXe DAO?
Yeah, sure. Once again, I suppose that taking into account the regulatory pressure and the point of development of our community, I suppose that we very need legal wrapper, DAO legal wrapper, which from one hand will protect community member and make their liability limited, and from the other hand, community as the whole will have off-chain mechanism to perform its decisions and to protect its rights in case of breach of some, legally binding relations by third parties against the community. Something like this.
Gotcha. Yeah, I think it's a really good way to sum it up. And for Irina, kind of sum up question, or maybe the last follow-up question, since this is about, this whole talk today is about legal strategies for DAOs, would you say that, for DAOs who are able to do it, your main recommendation in general is to form an association in Switzerland and, give a certain amount of time to account for processes taking a bit longer in Switzerland, or any other tips, kind of quick tips that you want to give to DAOs who want to create a legal strategy of this is how you get started, these are the main things you want to consider?
So I don't think there is one jurisdiction that will fit everyone. That's for sure, because every a typical lawyer will say it depends, because it does depend. It really depends what the DAO is doing. If the DAO is doing some DeFi staking protocols, then the Swiss regulator will not like it very much, because that really goes into the regulated area. In such a case, other options need to be looked at. But for what DeXe is doing is a perfect jurisdiction, in my opinion. Again, you're a technology focused entity. You are building on-chain governance and on-chain sort of like a DAO constructor for other DAOs. This is a great tech sort of use case for what you're doing. And in such a case, Switzerland is a great jurisdiction. I cannot give advice to every other DAO because I do not know what they do or what they're planning to do, but in regards to the jurisdiction. But the advice will be in general, think about several things, just Taras just mentioned, right? Think about protecting yourself as founders and your members as the members of your DAO, because DAO without members, it's nothing. Think about how you're planning to run that decentralization part, because a DAO without decentralization is just an owl, which is nothing. Think about how you're planning to interact with the real world. How will you portray that credibility and that tier one gist of your project, if you set up in a slightly questionable place, or you not set up, are you going to portray that authority? Are you going to portray that thought leadership? Maybe not. However, I do not know, maybe in some particular cases it will work. So each project needs to be considered separately, but in general, these are your 2, 3, 4 things to think about. How are you planning to decentralize? How you're planning to protect yourself and your members, how you're planning to issue the token, because it's very important to issue that in a compliant manner as well, which place you will call home, and that home needs to be strong enough to protect you from hostile regulators trying to assert their jurisdiction over you, and also the credibility of your establishment. It needs to be credible for other credible partners to engage with you, for credible members to become part of your DAO. So it's quite, it's a more of a commercial sort of consideration, commercial/technical, and then legal conclusion comes from that. Because from the legal point of view, there are so many ways to skin a cat. However, you need to sort of start from the very beginning. Where's the cat that we're trying to skin? Once we found the cat, then we can try skin it in a proper manner.
Thanks, Irina. I was definitely asking for trouble, asking an attorney to give a simple, but one-size-fits-all answer, and you definitely gave a very comprehensive explanation that I think any DAO would benefit from. And like you said, a DAO should be a DAO, not an DAO. So I think a lot of listeners will take that to heart. I will hope so. So I just want to thank both of you guys for coming today. And let's wrap it up here. But you've answered a lot of questions from our community today, and just amazing to see regular DAO members coming in and coming up with these very nuanced, very thoughtful proposals, and of course, with the crypto native expert attorneys also coming in and explaining these things, so it's a little more digestible, because ultimately, the whole idea to me of DAOs is that anybody can participate fully, and once people understand all the different aspects, including legal aspects, I think it really helps DAO members participate more fully, to understand their DAO more fully. And I'm, as one of those members, happy to now be more aware of what legal considerations, legal strategies are available and should be thought about. I'm going to be probably spending the next hour, honestly, just kind of replaying it, thinking it. Luckily, this will be recorded. This is recorded, actually. So, again, thank you, Irina. Thank you, Taras. Thank you both. Thank you, everyone who listened to us today. Stay tuned for announcements of the next one. Just really, you answered so much. Million thanks to both of you. And until next time.
Thank you very much for having me, and thank you very much for the space. Really appreciate your time.
Thank you, everyone. Thank you for attention to my proposal.